Lanka to participate, where we have one of the foremost authorities in arbitration speaking on how to manage construction disputes when faced with global pandemics and financial crises. I'm Anuruddha Pereira, co-chairman of the International Relations Committee of the Bar Association. And I warmly welcome you again on behalf of the President, Secretary, and the Executive Committee of the Bar Association, and the Chairman and the Convener of our committee. The Overseas Relations Committee of the Bar Association over the last 5 years has organized webinars, perhaps for the first time in the history of the BASL, which have attracted a large international audience. For example, today we have 276 registrations from 20 countries, and the participants extend from Americas to Africa, and then from Middle East to East Asia, so Southeast Asia. So it's a very international audience, and they are logging in as we speak. Our speaker today is Mr. Julian Bailey, a partner at the White & Case LLP London, where he practices international construction law. He's a visiting fellow at the Dixon Poon School of Law at King's College, and a detailed introduction to Julian will be given by our moderator, Dr. Asanga Gunawansa, who is a leading practitioner in arbitration in Sri Lanka and internationally. The panelists today are Justice Dr. Salim Masuf, President's Counsel, who is a former Additional Solicitor General, and Mr. Sumathi Dharmawardena, who's an Additional Solicitor General, President's Counsel, Mr. Sumathi Dharmawardena, President's Counsel, who's the Additional Solicitor General and Additional Solicitor General of the Attorney General's Department. And now I will invite I would like to invite Mr. Salia Piris, President's Counsel, the President of the Bar Association of Sri Lanka, to say a few words. Mr. Piris, over to you.
Thank you. Good afternoon. First of all, let me congratulate the Overseas Relations Committee of the Bar Association of Sri Lanka for organizing this webinar. I think the topic is very timely, especially as Sri Lanka itself faces the impact of COVID and also the impact of the economic crisis, which in turn have caused a crisis of a social crisis also in this country. So the Bar Association of Sri Lanka is committed towards supporting the legal community and also supporting the people of Sri Lanka in their efforts or in their efforts at facing the consequences of the crisis. And I'm sure the outcome of this webinar, the presentations of the speakers and the panelists will be useful for the legal community in Sri Lanka, but also to the wider community who have joined in to watch this webinar. I must thank Dr. Asanga Gunawansa, who is the chair of the Overseas Relations Committee of the Bar Association of Sri Lanka, Mr. Anuruddha Pereira, the co-chair, and Mr. Manjuka Fernandopulle, the convener of the committee, for the work they have put in contributed towards the Bar Association through the activities of this committee, especially this webinar. And let me thank the speaker, Mr. Julian Bailey, who I'm told is one of the foremost leaders of the field of ADR, and of course Dr. Salim Masuf, Justice Dr. Salim Masuf, President's Counsel, and Mr. Sumathi Dharmawardena, President's Counsel, Additional Solicitor General. Thank you very much for participating as panelists in this webinar. So once again, thank you to the Overseas Relations Committee, and the Bar Association looks forward to conducting more programs such as this in order to support our community. The last 1 year has been a very trying time for all of us in Sri Lanka, of course, also In the world also, the last 2 years have been a trying time, but for us in Sri Lanka, the economic crisis has added to the problems which have arisen. And we as the legal community, we have felt it our duty to support the citizens of this country, especially to establish the rule of law and to ensure that the rights of people are protected. So thank you very much.
Thank you. Mr. Salia Piris. Ladies and gentlemen, that was Mr. Salia Piris, President of the Bar Association of Sri Lanka. He's guided the bar, and the bar has taken a very strong stand in many of the topical events in Sri Lanka. And now I would like to call upon Dr. Asanga Gunawansa, Senior Counsel, who's our moderator this evening, to introduce the speaker and take the proceedings forward.
Thank you,
Anuruddha.
Thank you, Anuruddha, my co-chair of the Overseas Relations Committee of the Bar Association of Sri Lanka. I consider this a great honor to moderate today's webinar. We have 3 accomplished, well-trained and very knowledgeable speakers on the subject matter we are going to deal with, namely how to manage construction disputes when faced with global pandemic and financial crisis. One of the gentlemen we have today is the author of a much sought after legal text in the area of construction law, and I'm a great admirer of his work. Then there is a gentleman who has been a mentor and a friend to me over the years, and the third gentleman and I were at law school together and thereafter in university, and we have remained very good friends over the years. So let me introduce them to you now by saying this first. I'm not going to do justice to them by reading out their full resume in the interest of time. And I do invite all our attendees to simply do a Google search on their name, and you can agree with me that all 3 of them are very well accomplished. That said, let me first introduce our first panelist and the main speaker, that is Mr. Julian Bailey. Julian is a solicitor and a partner at White & Case LLP London, where he practices international construction law. He's a visiting fellow at the Dixon Poon School of Law at King's College London, and is an adjunct professor of law at the Hamad bin Khalifa University in Doha. Julian is a past chairman of the Society of Construction Law UK, and is the author of 3-volume treatise entitled Construction Law. Being from Australia, Julian is also an avid follower of Test cricket, and I am told that he's a fan of Muthaiya Muralidharan. And he specifically has spoken about Muralidharan's Dusra. So I think if he ever comes to Sri Lanka, we have to take him to the cricket cafe and treat him to the Dusra burger that is named after Muthaiya Muralidharan. Our next panelist is Justice Dr. Salim Masuf. Justice Salim Masuf is the former Additional Solicitor General of the Department of the Attorney General of Sri Lanka and a President's Counsel. He held office as the President of the Court of Appeal of Sri Lanka and thereafter as a Judge of the Supreme Court of Sri Lanka. He is currently a non-resident Judge of the Supreme Court of Fiji, an elected member of the Faculty Board of the Faculty of Law of the University of Colombo, and a leading commercial arbitrator in Sri Lanka. He's also an educator, and he has educated thousands of lawyers in Sri Lanka, including myself. Our last panelist is Mr. Sumathi Dharmawardana, Attorney at Law and President's Counsel. He's a Senior Additional Solicitor General attached to the Department of the Attorney General of Sri Lanka. He has an LLM from the National University of Singapore and a trained and accredited adjudicator of the Asian International Arbitration Center. He's also a member of the panel of arbitrators of the Shenzhen Court of International Arbitration in China. Sumathi is an expert on commercial law, arbitration, and sports law. He had acted as a legal consultant to the Telecommunication Regulatory Commission of Sri Lanka and has assisted in the drafting of regulations in that area. He is also a member of the Appeal Board of the Sri Lanka Anti-Doping Agency. That said, I will now, first of all, I welcome all 3 of you to this webinar, and now I will open the stage for Julian to make his presentation to our attendees. Julian, over to you. Thank you very much.
Well, thank you very much, Dr. Asanga, and thanks for that kind introduction. I look forward to trying a Dustra burger on my next visit to Sri Lanka. I'm sure it's very tasty. And look, congratulations to the Bar Association on organising this webinar. I think it's a fascinating and wonderful initiative. And with that, what I'm going to try to do, see if this works, is share my screen with you. So let's try. Can you see my screen? Can someone please let me know if that's there?
We can see the screen.
Yeah,
we can see.
Just want to make sure I can go through my slides. Right. And can you see the next slide? Can someone say yes? I can see that. Okay, good. Right, then it's all working. Great. Okay, well, look, what are we going to be looking at? We're going to be looking at circumstances which are right in front of us, not only in Sri Lanka, but all around the world. We face various crises, and they throw up all sorts of issues, social issues, as has been mentioned, but also economic and legal issues. So what I'm going to try to cover in this little presentation is just to give you an idea of some of the main issues and how they might be dealt with in a construction context from a legal perspective. So we're going to start by looking at identifying what the crises are. It's not just one crisis, it's several, unfortunately. And then we'll go into some of the details concerning them, such as COVID. We'll look at supply chain issues, the big problem of inflation. And then finally, we'll look at issues concerning payments and funding, which seem to be a major problem for many people. So where to start? Well, in a sense, I don't need to show you these slides because this will all be familiar to people who are watching and listening in. We have all sorts of crises going on in the world. COVID came around unexpectedly in early 2020. We've got the Ukraine situation going on with the conflict between Russia and Ukraine. That's causing all sorts of problems, not only, of course, within Ukraine, but internationally. We have supply chain issues, and you can see that that famous ship that got stuck in the Suez Canal, that's there. And that's just one example. We've got many other examples of supply chain issues affecting the world. And of course, locally in Sri Lanka, you don't need me to remind you of this. You've had extremely serious issues within the country, which are still causing problems for people, which is unfortunate. And hopefully there can be a way through this for everyone. So what do these issues add up to? Well, I think if we're looking at the construction industry context, what they add up to is a number of problems. And just looking at some of these pictures here, we've got the top left, construction sites were either shut or operations were reduced when COVID was affecting things. Below that, we can see inflation. I mean, inflation's just gone crazy everywhere, it seems, in Sri Lanka and many other countries. That's having a big impact on the cost of materials and the cost of projects. Up in the top right, we see a well-known actor saying, "Show me the money." Well, people getting paid is a big issue. I mean, it's always an issue in the construction industry, but it seems to be even more acute now because of these global issues. And then, of course, we've got the issue about getting materials and labor, which are essential elements for any construction project. That's a big issue. So we've got all these issues floating around. We'll address them as best we can one by one. Let's start with COVID. Again, this will be familiar to everyone, I'm sure. The history of COVID, all too familiar actually. I've got a few pictures here. One thing to demonstrate, hopefully, in the slide or the graphic you see on the left is really the experience that we've had of COVID, which is that we'll remember that 2020 was very difficult. We didn't have any vaccines, and COVID was having a major impact on everyone. And then we had the vaccines coming along last year, thankfully, and they seem to be quite effective. So in terms of reducing the mortality rate and helping lives in most countries get back to normal. But what we'll look at more in a moment is, and you've seen this, I've got these other two pictures here. What I want to talk about is the impact of COVID on the construction industry, because I think it's had an impact in two ways, really. The first one is people being sick, like the gentleman up there who's got COVID and not feeling too well. So if he worked on a construction site, he wouldn't be at work because he's off sick with COVID. But then we've got other things as well. If you look in the bottom right, you see a sign there saying, stay home, don't go to work, save lives. We also had laws relating to COVID, and I'm sure you had them in Sri Lanka too, which restricted the movement of people. So irrespective of whether someone had COVID, people were told to stay at home, or in some cases not go to work, such as a construction site. So I think we need to differentiate between the two different problems. Number one is the problem caused by people being sick with COVID. And the second one, which I think has had the greater impact actually in the construction sector at least, are these COVID laws, which have involved social distancing, which might have involved construction sites being closed, which involve restrictions on the travel of people between countries and within countries as well. And if we want to try to get a sense of what the legal effect is of these matters, I think looking at things from an English common law perspective, it is fairly simple actually, because the general position of English law in relation to matters such as COVID or indeed COVID laws is that they provide no excuse for a person not performing their contractual obligation. So English law doesn't offer any kind of relief at all to someone who signs a contract saying, I will build a building by a particular date. The only excuse comes if the situation is so bad whereby the contract can't be performed at all. The basis of the contract is gone, in which case we say the contract is frustrated. But I would say by and large, this hasn't been the case in relation to COVID. I think we all have different experiences of COVID, but at least in my experience, and I have an international practice, I haven't seen any projects that have had to be abandoned because of COVID or COVID laws. So what this means as a matter of common law is that the contract is capable of being performed, and therefore the contractor is bound to perform what it has promised to do under the contract, and has no general relief under common law in relation to COVID. Now, what this means is that if a contractor wishes to seek relief, more time and possibly more money in relation to a project, it has to go to the provisions of the contract itself to see whether they afford any basis for relief. And when it comes to what relief construction contracts commonly afford contractors in situations like this, we have COVID or a COVID situation, there's usually one of two approaches. The first one is to say, well, if the COVID, for example, causes delay to the contractor may be entitled to more time for completing the works. So there's a right to an extension of time, but there may be no entitlement on the contractor's part to be paid its additional cost because the project has been delayed due to COVID. So the relief under the contract may be time only. That's the only form of relief, and the contractor has to absorb its additional cost. Now, the second possibility is that the contractor, if it's delayed by, say, COVID, it can claim an extension of time for completing the works. And if it incurs additional cost, the contract may permit it to make a claim against the employer for those additional costs. And that's the best situation for a contractor, which is faced with COVID or something similar to that. It gets an extension of time and it gets paid additional money because of the delay and disruption caused by COVID. Now, all this begs the question, well, what do contracts actually say in relation to these sorts of situations? There are many types of contracts out there. The most widely used one internationally is the FIDIC form of contract, which I think is used in Sri Lanka, is used in many other countries around the world. So let's have a little look at what FIDIC says in relation to something like COVID. Where do we start? Well, I think we can start with this clause, which is 19.1, which deals with force majeure. This form of contract, I should add, is the 1999 edition of FIDIC. There was a 2017 edition as well, but it's not that widely used at the moment. So I think it's best to look at the 1999 form because it has greater currency. So what does this contract say about force majeure? Well, it defines it in 19.1. If you look at where the red arrow is pointing, it defines force majeure as an exceptional event or circumstance. And let's look at this in the context of COVID, which is beyond the party's control. That COVID is certainly beyond the party's control, which such a party could not reasonably have provided against before entering into the contract. I think that's certainly true if you look at contracts entered into prior to, say, February or March 2020. No one knew about COVID. And then you've got C, which, having arisen, such party could not reasonably have avoided or overcome. That's probably true as well in relation to COVID. It appeared no one knew what to do. We didn't have any vaccines or anything, so a contractor couldn't really have addressed it. And the last criteria is that the event, in this case COVID, is not substantially attributable to the other party, and that would be the case too. COVID is a neutral event. It came out of nowhere. It was no one's fault, at least in the context of an employer and contractor relationship. So that's good insofar as a contractor is concerned, because it means that there is force majeure in the sorts of situations that we've seen arising over the last couple of years. Then in this particular form of contract, what it does is it goes on to say force majeure may include, the word may, but is not limited to exceptional events like those listed below. And we see a whole shopping list of events like war, rebellion, riot, explosive materials, natural catastrophes such as earthquake, etc. What you don't see is pandemic or a similar type of word mentioned there. So COVID does not fall within any of these particular types of force majeure events. It's still a force majeure event because it fulfills the criteria of A to D, which you see here, but it doesn't come within any of Romans 1 to 5. And that's significant when we, as we'll see in a moment, when we come to looking at time and cost consequences. Now, I want to look more generally at what outside of FIDIC has been the judicial experience of COVID, at least in the construction sector. And it's fair to say that it's been very limited. There have been cases in the common law courts dealing with COVID, but not in a construction context. Although we did have a decision from the Singapore courts relatively recently, which I think provides a neat summary of how certainly the courts of that country and maybe indeed the courts of other countries will look at COVID. Is COVID a force majeure sort of event? And the court there said in this case, which is GTMS construction, force majeure events and circumstances are radical external events and circumstances that prevent the performance of the relevant obligations and which are due to circumstances beyond the party's control. For example, COVID-19 pandemic and the lockdown that followed over much of 2020 and 2021, the shortage of labour and materials due to COVID-19, the prohibition of travel between countries and the ensuing disruption of supplies and manufacture of goods and materials. So there's a nice, neat and clear, very clear statement from the Singapore courts that what we're talking about in relation to COVID on any view represents what might be described as force majeure. So that's a very clear and I think helpful statement coming from the Singapore courts about COVID. Now let's return to our friend, the FIDIC contract, and see what it says in relation to COVID being force majeure. So we looked at the clause before, which defines what force majeure is. And I think we can safely conclude that COVID would be a force majeure event. What is the consequence of there being a force majeure event? Well, you can see it here in 19.4. It says, if you have one of these force majeure events, then the contractor may seek and obtain an extension of time, this is A, for completion, for being delayed. But if the event or circumstance is of the kind described in subparagraphs 1 to 4 of the clause, then there may be cost. Now let's just go back 2 slides to see what this means. So it's saying that if COVID falls within these Roman numerals, so war, hostilities, etc., then the contractor can claim cost. But because COVID doesn't fall within any of those, then what it means under this contract is that there is an entitlement only to an extension of time. A contractor which is affected by COVID gets an extension of time, but is not entitled to be paid its additional cost because of the COVID. Now, some people like David Crosby, who you see here, may say, well, it's all about the time, man. And maybe that's true in a broader sense, but for contractors, they want the time and they also want the additional cost to them to make themselves whole, because COVID has a huge financial impact. But force majeure isn't the end of this. And if we look in construction contracts, they contain other provisions which may assist contractors, perhaps even in greater ways. The type of provision that's most commonly been utilized by contractors over the last 2.5 years or so is a provision like this. And this is a change in law provision, which you find in the FIDIC contract. And I won't read out the full text of the clause, but the gist of it is that if there is a change in law that affects the contractor and causes it to be delayed or incur additional cost, then the contractor may A, seek an extension of time due to the change in law, and B, seek the payment of additional cost. So the contractor, for a change in law, gets time and money if the change in law affects it in such a way. And this has been a powerful tool for contractors that have been affected by the COVID situation, because if we think about how COVID has impacted people the most, at least in the construction field, for the most part, I think it hasn't been because workers have been off sick with COVID. It's been because governments around the world have rightly created laws to regulate the movement of people, whether businesses can carry on, etc., to limit the movement of COVID, to control it. So this has had the greater impact on contractors, and this is good for contractors in a way, because it allows them to claim both time and money and to make themselves financially whole due to the impact of COVID laws as opposed to COVID itself. Now, so that's kind of a little overview of how contracts, or at least the FIDIC contract, deals with this type of claim. What I think we need to consider as well is, what does the future look like in relation to COVID claims? Here we are at the end of 2022. We have vaccines. We can control COVID. For most people, life is back to normal. I'm here in the United Kingdom, where, for practical purposes, normal life has resumed. There's no social distancing or anything like that, and businesses are not affected by COVID. So that's good. But what if COVID, some variant of COVID, materializes in the future, which it might be a nasty one and requires us to go into a lockdown? Could a contractor make a claim on the basis of COVID being force majeure, being unanticipated? That we'll have to see if that unhappy situation materializes, but that could be open to debate, because COVID is a known thing now. So from a force majeure angle, it could be open to argument. However, in relation to changes in law, I think the position will probably be a bit clearer, because no contractor really can anticipate what laws the government of the particular country will impose in the future. And I think, therefore, change in law provisions, like the ones we were looking at a few moments ago, will still be of relevance to contractors, and may be capable of being utilised in the future for any future code situation. But hopefully, we won't be in that situation ever again. Right, so let's move on from COVID to yet another problem, which is slightly related to COVID, I suppose, which is the global supply chain issue that's affected the construction industry around the world, including in the United Kingdom. Here you can see a headline from earlier this year: thousands of lorries queue as delays hit Dover-Calais crossing. This was related to a number of things, including COVID and including Brexit, actually. But the point to note here is that supply chains are under great strain at the moment, and it's often difficult for those in the construction and engineering industry to obtain necessary elements for the projects, goods that are needed to make the project work. So that's an issue. And the question for those who sign up to construction contracts is, if they can't get the goods they need for building the project, whatever it is, does this create some kind of entitlement to contractual relief? And potentially it does. If we go back to our friend, the FIDIC contract, and this is the definition of force majeure that we were looking at a few moments ago, let's consider this in the context of a supply chain issue. So a contractor is trying to get goods from, say, China, but all the ports in China are suddenly all blocked up and nothing moving. So can the contractor say, well, this is force majeure? Let's look at the criteria again. So we have A, is this event beyond the party's control, beyond the contractor's control? Yes. Is it something that the contractor couldn't have provided against before entering into the contract? That's probably true as well. And then once the issue arises, the supply chain issue, say at the port in China or wherever it is, could the party have avoided or overcome the issue? Maybe, if you can get the goods from somewhere else. But what if you can't? What if they're unique items made specifically for this project? And then the last criterion, which is not substantially attributable to the other party. So it's not the employer's fault. That would be the case. So if we have a situation of a supply chain crisis on a project, potentially for a contractor, that's good news, because the contractor could claim more time because of the supply chain issue. But we'll remember from looking at the provisions of this clause, this doesn't mean the contractor can claim more money for the delay ensuing because of the supply chain problem. So there's a mixture of risk allocation in relation to this matter. The contractor gets more time, but the employer doesn't have to pay any more. And there's another provision actually in this form of contract, the FIDIC form, which is even more specific in relation to this matter. This is the extension of time clause. This is subclause 8.4, and it includes a shopping list of matters that may entitle a contractor to claim extension of time. The most relevant one is the one you see there with the arrow, and is unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. Now that could potentially be of relevance here. If we take, for example, the recent issues in China relating to supply chain or causing supply chain problems, which because of various lockdowns in China, it seems that has slowed the ability of goods to be shipped out of China, and this has led to an unforeseeable shortage in the availability of goods. So that could be another ground which a contractor could claim an extension of time, but not additional cost because of its work being prolonged. So supply chain issues may be ones which entitle contractors to time relief, but not money relief. Now, what about this other issue, which is in some ways the greatest issue at the moment for many in many countries, which is the cost of materials going through the roof? And you can see I've got a graphic here from the United Kingdom alone, and I'm sure it's similar or perhaps worse in many other places, showing that inflation from about late 2020, I guess, into 2021 just went through the roof. And so all these materials are suddenly costing so much more money. And this is having a big impact on the cost of construction and engineering projects, both to contractors and employers. So the issue is what are the legal issues? What does the law say about risk allocation in relation to things like inflation? Well, you won't be surprised to know that the common law takes a fairly hands-off approach when it comes to these matters. And it says, in essence, that if the cost of materials or labor or whatever it is goes up, or maybe even goes down in some way, that has no impact on the contract price for the works, unless the contract itself includes a mechanism for adjusting for inflation. And we'll look at mechanisms in a moment. What are the available mechanisms to parties to deal with inflation? This ultimately comes down to risk allocation. This is a matter for agreement between the parties. The law doesn't seek to impose any constraints or restrictions on what parties may agree in this regard. But there are a few options that exist. And the first one is to have a fixed price contract. This benefits the employer the most in terms of risk allocation, because it means that if cost of materials goes up or the cost of labor goes up, the contractor is taking the risk on it. So the contractor can't claim more money because its costs have gone up. The employer can say, well, the contract is fixed price, and that means if your costs go up, I still pay the same. A different approach, which involves a sharing of risk, is what's called a target cost approach. And this involves the parties agreeing in the contract that the target price for the works shall be X, and that if the cost of the works goes over X, then the employer absorbs some of the overrun, and so too does the contractor. And similarly, if the cost is less than the target, and this is not a very common situation, then the parties get to share the savings. So that's another way of dealing with things like inflation, and that's a reasonably popular or increasingly popular mechanism for parties, because it involves a certain amount of fairness between the relevant actors in terms of risk allocation. The third one, which is really at the other extreme from the fixed price model, is cost plus, and this means, as the name suggests, that the contractor does the work, it sends its invoices, etc., to the employer, and that's what the employer pays. The employer pays the cost of the work plus a margin to the contractor, and this puts the risk of inflation entirely on the employer, and so that's another possibility as well. And then there's another mechanism which I've mentioned here, which is the use in an otherwise fixed price contract of a provision. It might be called a rise and fall clause or an escalation clause or something like that, which means that if certain costs, and it's only certain costs, change during the life of the project, the contractor can claim more money. And this means the employer takes some of the risk of there being inflation. And as an example of that, you can see it in the FIDIC contract, where I've rather badly cut and paste an extract from the contract. How does it work? Well, in this subclause, is 13.8. It basically permits the contractor to claim an adjustment to the contract price if certain economic variables change during the life of the contract. And you can see it's a rather complicated looking formula that's used in this rise and fall clause, and that is used that uses various indices, industry indices about costs of materials and labor and so forth, to work out what the price adjustment should be. And it is quite messy, not quite as messy as the or as difficult as the calculation you see on the slide here on the blackboard, but it's still quite involved. So one of the reasons why these rise and fall clauses, which first gained currency in the 1970s when there was an oil shock and great inflation, but one of the reasons why they're not that popular is that they are actually quite difficult to operate, because they involve a number of different variables, and the formulae are quite involved. The other problem that can arise is when these rise and fall clauses use some kind of industry index, as they always do, and there are problems that can arise when either the party misidentifies the particular index, or sometimes these indices are discontinued by the relevant body that publishes information about, for example, the cost of materials. So rise and fall clauses are probably not the solution. And is there a solution here? I'm not sure one easily finds it, and depends on which angle you're coming from. But I've concluded this section with a suggestion, which is that cost plus contracts are often a good way to go, not for everyone, but where there is a sophisticated employer which knows how to work with contractors, and the contractors have worked with the employer before, and there's mutual trust between them. Then what can be done sometimes is using good construction management, procurement and techniques, is the employer can control the work that the contractor does and thereby control the cost. The contractor is still paid its cost of the work plus a margin, but through a process of management, the overall spend can be regulated in often a satisfactory way. Right, so this takes us on to the issue, which is a burning issue, of course, at the moment in Sri Lanka, of payment and funding. And on the slide, I have a fairly recent headline. I'm sure this is close to home for everyone in Sri Lanka at the moment, where there are big issues about people getting paid, and that of course flows from the extremely difficult circumstances that Sri Lanka finds itself in, which are hopefully going to be corrected soon. But it's a problem, and if we look at it in a broader sense, it's a problem in most countries for contractors, which is getting paid. You do the work, you submit your invoice, and you might have to wait weeks, months, sometimes even years to get paid. It's a big problem. So the question is there a silver bullet? Is there an easy solution to sort this out, to make sure that we don't have payment problems bedeviling the construction industry wherever you are in the world? I'm not sure we do, but what I will offer to you is some thoughts. And these thoughts come from a legislative scheme which applies in England and other countries. And this is called Statutory Adjudication. And it arises by virtue of an English statute that came about in the 1990s. It has a very long name. It's the Housing Grants, Construction and Regeneration Act 1996. Us construction lawyers abbreviate that to the Construction Act because it's a bit of a mouthful otherwise. Now, what this act provides for, among other things, is a process of dispute resolution, which is called adjudication. And well, I won't give you the full details, but essentially what this permits a contractor to do is to have a fast track form of arbitration in effect. So if a contractor hasn't been paid, it can start an adjudication against an employer, and the adjudicator, the person who's deciding the dispute, is required to reach a decision within a period of 28 days of the dispute being referred to adjudication, or possibly a little bit longer than that. Not much time, you might think, and it isn't. And this isn't necessarily a problem, because the decision of the adjudicator isn't final and binding, it's provisionally binding. But what it means is that if a contractor obtains a decision in its favor, say the adjudicator decides that the contractor is entitled to £100,000. Now, the contractor gets that decision in a fairly short space of time. If the employer then doesn't pay, the contractor can take it to the courts here in England, the Technology and Construction Court, and the courts fairly quickly, within a matter of a handful of weeks, will enforce that adjudicator's decision and make it into a judgment in the same way as an arbitrator's award will become a judgment of the court. And so then the contractor, within a matter of weeks, has a judgment against the employer for the sum that it's owed. And it doesn't have to go through a long process of court proceedings, a full trial or anything like that, or a full arbitration hearing, which can take many months or even years sometimes. So this has been seen as a good thing in terms of providing fast track dispute resolution. And the top court here, the Supreme Court, has given it its endorsement for this form of dispute resolution. I've got a quote here from this case from Bresco and Lonsdale, where Lord Briggs gives a nice little summary of how the courts see it. So he says, introduced as a statutory regime by the 1996 Act, adjudication of construction disputes has been conspicuously successful, in addition to the range of dispute resolution mechanisms available for use in what used to be an adversarial litigious environment. So there you have a judge of the top court saying this is a good thing. It gives the construction industry a fast way of resolving disputes. And this form of dispute resolution has been popular. It's worked, actually, in the United Kingdom. No one is saying, well, it's a disaster, it's created all sorts of problems. No, it's seen overall as a beneficial way of dealing with construction disputes. And this type of legislation has, as some people may know, being adopted in slightly different ways, but with the same idea in a number of countries, including Australia, New Zealand, Singapore, Malaysia, Ireland, Canada, the Isle of Man. That's the three legs you see down the bottom there. And who knows, maybe Sri Lanka itself could give some thought to this, because it has proven itself to be a very useful form of dispute resolution for the construction industry. So let me conclude there with a big thank you for having me, and I'll see if I can stop sharing my slides. There we are. Thank you.
Thank you very much, Julian, for that very thought-provoking and detailed presentation. Can I be heard?
Yes, Sangha, we can hear
very
you.
well. Okay, right. My screen had a frozen picture of Julian, so I was a little concerned about that. So thanks again, Julian, for that presentation. It was very detailed and very educational, and I'm sure all our participants, including the panelists, have learned a lot from that, and some things we can certainly consider applying in Sri Lanka, and perhaps see what improvements we can propose to the Sri Lankan legal system as well. And I know, as a matter of fact, the Chamber of Construction Industry in Sri Lanka for a while now has been pushing for statutory adjudication. following the statute in UK and then also in Singapore. But unfortunately, it has not been successful thus far. But perhaps one day we might be able to have a statute like that here as well, which might certainly help the contractors and the suppliers, subcontractors, and so on. Because as we all know, lifeblood of the construction industry is money. So if we maintain the cash flow, then the industry will go forward. Now, that said, let me jump into the questions, because otherwise we might run out of time. I have few questions ready, and there are a couple of questions that have come from the audience as well. I will put that across later. And I have few questions ready for you, Julian, and also for Justice Mansoof and Mr. Sumati Dharmawardena. But let me start by putting a question to you. So I'm going to share my screen because the question is slightly long, and while I read it out, maybe the participants can read it as well. So Julian, my first question is this. In your presentation, you stated that frustration is a common law remedy for construction contracts which are affected by inflation and exchange rate fluctuation. How can one go about setting up a claim based on frustration if inflation and exchange rate fluctuation is due to market conditions? If somebody makes a claim accordingly, could not a counter argument be made that market risk has to be borne by the contractor? Could you kindly consider that question and share your views with us?
Thank you very much, and thanks for the excellent question. Look, I think when we're looking at frustration, we need to understand what frustration means in a common law environment, because it means the termination of a contract. It doesn't mean the contractor is entitled to additional money because of inflation or exchange rate fluctuations or anything like that. It means, as a matter of law, the contract comes to an end. And I think the thing to understand about frustration, if we're talking about these things like prices going up in some extreme way, is that they will not generally permit a contractor to claim that a contract has been frustrated. And so if we're looking at the last question there, could not a counter argument be made? The market risk has to be borne by the contractor. That's basically the common law approach. And so it's only if something is so extreme, let's say inflation was or suddenly became 1,000% overnight, then maybe that could be used as a basis for claiming frustration. Otherwise, I think the common law would say this is a risk that the contractor bears.
Just to follow up on that, because when you dealt with the issue of inflation, you also spoke about different measures that can be adopted at the time parties negotiate and enter into contracts to deal with it. For example, you even mentioned subclause 13.8 of FIDIC, which allows for price adjustment. Now, what we see in this part of the world is that very often when the standard form contract, when they're adopted, by way of particular conditions, the standard clauses are amended, or sometimes clauses are taken out altogether. And we see, especially in public sector contracts, this price adjustment clause is taken out or deleted by way of conditions of particular application. And then we have situations like what we are facing today, where prices fluctuate and the contractors can no longer deliver project at the agreed price. And there are no contractual remedies available to them because the subclause 13 point that you mentioned earlier has been deleted. And have you come across situations like that in other jurisdictions? And if so, are there any jurisprudence that could be useful in a Sri Lankan context?
Thank you. I mean, I think when it comes to things like there being no scope for adjusting under the contract price because of inflation, as a matter of common law, contractors are really stuck, and they can't seek more money, which then takes them maybe out of a legal situation of power into a commercial situation where they have to go to the employer and say, look, we know we're stuck with this price, but we can't go on. So can we renegotiate the contract? I've seen that happen, and that's more of a non-contractual solution. The other thing that I have seen, because my work covers not only common law jurisdictions but civil law jurisdictions, is that in civil law jurisdictions there's usually scope for a contractor, which is affected by something like extreme inflation, to be able to seek more money or an adjustment of the contract price on the basis of hardship or something equivalent to that. But I suppose the main point to mention, if we're looking at the common law, is that the common law takes a very hard-edged approach to all this, and which is why negotiating the contract is the most important thing for the contractor, because you can't renegotiate it as of right later on.
Thank you, Julian. There are a couple of questions I'll come back to you in a bit, but in the meantime, let me put a question to Justice Salim Masood. Justice Masood, according to the applicable laws in Sri Lanka, could situations like COVID-19 be treated as a force majeure event, and which would excuse the parties from performing contractual obligation? Do we have any judicial authorities supporting that argument? Justice Masood, I think you're on mute. We can't hear you.
Yeah, thank you, Asanga, for that question. But let me begin by congratulating our main speaker, Julian Bailey, as well as the Bar Association of Sri Lanka and you yourself, Asanga, for making this conference possible. In fact, the lecture we heard has been very enlightening and thought-provoking. And having said that, in regard to your question itself says applicable law. You want me to enlighten you on everyone else on the applicable law. And as far as Sri Lanka is concerned, first thing to understand is that in terms of the introduction of English Law Ordinance number 5 of 1852, only certain types of contracts are governed by English law. For instance, what comes to my mind are contracts involving insurance. Fire, life, and marine insurance are governed by English law. But other types of insurance governed by the Roman Dutch common law. Because in Sri Lanka, we have the Roman Dutch common law, which is the residuary law, which is what the Dutch who ruled Sri Lanka about several centuries ago left for us. And it is still the common law of Sri Lanka. And to that extent, even service contracts, including building construction contracts, subject to whatever contractual clauses we have, are governed by the Roman Dutch law. So the way the Roman Dutch law treats frustration is different from how it was treated by the English law prior to 1852, in particular, prior to 1940. Let me see, the frustration, 1943 in particular, because in England, we had the Law Reform Frustrated Contracts Act in 1943. And it, to some extent, mitigated certain issues that were created by the common law principles of frustration, which were a little inequitable for the reason that a frustrating event was resulted in a person being excused from performing his liabilities or duties only to some extent. And it did not give an equitable position, which was changed by the, to some extent at least, by the Law Reform Frustrated Contracts Act of 1943. But as far as the Roman Dutch law is concerned, which is applicable, I think, mainly for the construction industry as well, in the Roman Dutch law, the law is much more balanced, and it permits even some amount of relief against unjust enrichment. We have a golden thread, which Professor Veeramantri says runs across the Sri Lankan legal fabric. To that extent, the Roman Dutch law rule is that where performance becomes impossible, the whole contract comes to an end unless it is self-induced. If it is self-induced, there is no relief, but the contract comes to an end. And whoever who had to make some performance or payment is excused from that, from the point of the frustrating event. And if an action is filed by anyone to compel someone to make a payment or someone to perform, then there is something called the exceptio non edimpleti contractus, which gave relief by way of some kind of discharging him from responsibility. So the Roman Dutch law principle governs in a more equitable way as we see it. But then, as was explained very much by Julian, we have to negotiate contracts to meet contingencies that may arise. And for that, I think even very, very well-drafted clauses can assist. I must say that in regard to this, one issue that was discussed by Julian also was the question of force majeure, how it is triggered. Because one of the basic features of force majeure clauses is that it's something that is unforeseeable. So the matters that, or the events that trigger force majeure are firstly that it can be something like a pandemic or any other event, but which may have been expressly provided in a contract clause. And if it is not provided expressly or explicitly, there may be ways in which it may have been covered by some kind of language that is covering that situation. And also, consequences of pandemic may themselves constitute a force majeure event. Example, embargo, enforced curfew, such as independent trigger the force majeure clause. So in having our force majeure clauses drafted in such a way to bring about greater equity, and also adopting adjudication as a way, because ultimately for the constructor as well as the person who engages him, the time is money. And if time lost, there can be problems. So very, very quick ways in which disputes can be resolved and can help. But in force majeure situations, we have the difficulty, as we have discussed about economic crisis, there can be problems which sometimes the government has to step in, as it happened in Singapore. So that is my response to the question.
Thank you, sir. And just to follow up, now, going back to what you said about the concept of supervening impossibility in Roman Dutch law. Now, when that applies, as you said earlier, a contract can come to an end. Whereas in a force majeure situation, there can be two different approaches. I mean, it can excuse you for delay, and that doesn't mean that contract can come to an end. But then if the delay is prolonged, for a certain period of time, then due to force majeure, you can terminate the contract. So in that context, do you see having a force majeure clause in a contract provides more flexibility rather than allowing the Roman Dutch law principle of supervening impossibility to apply?
May I answer that in two ways? Firstly, I think you will remember a decision which was given in the 50s, I think. It's Pires versus Gaul Municipal Council, where the issue that arose was there was some kind of non-performance, and the court held that the principles of unjust enrichment can be utilized for recovering whatever the loss that is suffered by a person. And that also involved the construction of the Gaul town hall, so to speak. So that case gives some kind of basis for unjust enrichment to be used in such situations. And that is why the remedies that are provided in Roman Dutch law also can be useful. But in addition, I think that well-negotiated, well-drafted clauses which can allow price adjustment can be very important.
Thank you, sir. I think our audience is eagerly waiting to listen to my good friend Sumati Dharmavardhan. So let me put a question to him. Sumati, the question to you is, the Chamber of Construction Industry has estimated that the total overdue payments to contractors in the road, buildings, and water supply sectors in Sri Lanka from government contract exceeds over rupees 100 billion. Now, I know this is a difficult question, but given the current economic crisis, it is unlikely that the government institutions will be able to pay the contractors in the near future. So in a situation like that, what is the legal way forward as far as the contractors are concerned to find some relief?
Thank you, Asanga. I hope you can hear me.
Yes.
First of all, I must congratulate the Bar Association of Sri Lanka, and especially for an enlightened session by Julian of White and Case LLP. In fact, we had a recent training program organized by the Department of Commerce of the United States with White and Case LLP on FIDIC contract conditions. And thank you for that presentation, Julian. And it was a very enlightening session. And especially we have Justice Salim Masuf. Having listened to everybody, Asanga, you have put me on a spot because I represent the Attorney General of Sri Lanka. But with certain limitations, I would be very happy to answer this question. Especially, you have estimated the amount due from the government of Sri Lanka to contractors is around 100 billion. But according to a newspaper report I came across yesterday, 5th December 2022, published in Daily News, it says the amount is 200 billion. It's a fairly big amount. Having said that, the Daily News reports that the central bank governor has mentioned in passing the settling of rupees 25 billion by end of the year. So it appears that the government of Sri Lanka and the central bank had taken note of this huge issue, which has come up as a result of the unprecedented economic crisis faced by Sri Lanka. Having said that, I came across an interesting cabinet decision because number of matters have gone before the court, and in a writ application, I was informed by the Ministry of Finance, Economic Stabilization and National Policies, a cabinet memorandum was submitted in July 2022 to take note of the issues pertaining to price variation for contracts of goods and services to accommodate under the current economic situation in the country. And they have appointed a committee in the Ministry of Finance. And according to that, they have authorized the Treasury Secretary or the Deputy Secretary to consider case by case of matters pertaining to supply of goods as well as services due to the economic crisis. When I said due to the economic crisis, it's twofold. One is the government has put a restriction on importation of necessary items, and they have only permits a limited number of items to be imported. But the Treasury is taking case by case and assisting the suppliers and the contractors to come out of the crisis. And in one matter which came before the court, there was a very positive response from there. So what does that mean? That means that for this matter, they are considering some sort of negotiations. They call the contractor and then they get the response from the particular government ministry or the agency, and then they evaluate what type of project, whether it's very important and whether it can be postponed the coming year, and thereafter they resolve the dispute. So I think the question what you raise is that what is the way forward for such a situation? I think the way forward is, number one, is to negotiate. And in fact, if I refer to the 1999 red, yellow, and silver books, where clause 20.5 speaks of amicable settlement, where notice of dissatisfaction has been given under subclause 20.4 above, both parties shall attempt to settle the dispute amicably before the commencement of arbitration. Therefore, I think the government of Sri Lanka has taken a step forward to appoint a committee chaired by a Deputy Secretary of the Treasury to look into the supply of goods and services. That's one way. Second thing is, I think if there is no proper contractual conditions, there's a way to involve the Honorable Attorney General by issuing a Section 461 notice in terms of the Civil Procedure Code, giving intention to institute action against the government of Sri Lanka. Not that I'm inviting the lawyers to issue 461 notice, but I'm enlightening them that if the matter cannot be resolved through negotiations as provided in the cabinet decision, they can make use of Section 461 of the Civil Procedure Code to issue a notice of an intention to commence legal action to recover damages. And based on that, the Attorney General call both parties and try to resolve it. And I'm sure there will be a very constructive way forward in order to resolve these issues due to the unprecedented economic crisis. I think I may have covered your issue. Due to my limitations, I can't go beyond this.
I understand. Thank you very much, Mr. Dharmavardhana. So there are a couple of questions that have come from the audience also. So therefore, I'm going to reduce the number of questions that I had planned to ask you. But I'm going to put this last question to all three of you. This, Julian, is something that is specifically relating to the current Sri Lankan situation, but I'm sure you can give some input as well. So I will first invite Sumathi to give a brief response, and then Justice Masup, and after that you, Julian. And thereafter, I will put a couple of questions that have come from the audience. So the question is, the government of Sri Lanka has introduced recently the policy decision on advocating deferred payment letters of credit. And this happened around June 2020. Making it compulsory for all imports to be on a minimum 90-day credit facility provided by a foreign supplier. Now, around this time, another policy decision was taken to free float the rupee against the US dollar. The resulting position was that, especially in the construction industry, when construction material is ordered, like the good old days, the money doesn't go out on the LC the moment the goods are shipped by the importer in another country. The money goes out after a 90-day period. And during this period, for example, the US dollar, which was trading at 206 or 230 rupees for a one USD, went up to about 370 rupees per one USD. And as a result of that, the local purchasers or developers suddenly had to pay approximately 60 to 70% more for purchase of construction materials, which was something that they never anticipated at the time of entering into contracts. Now, can this situation be covered under a force majeure clause as well as a change in law clause that is found in standard form contracts? So that is my questions to you. Sumathi, if you can have your response first, and then Justice Masup, and after that, Julian.
Thank you, Dr. Gunawansa, for raising that question. As I mentioned to you, before I come into the force majeure issue, government of Sri Lanka, having considered this scenario, in the cabinet memorandum submitted in July 2022, decided that to authorize the Secretary to the Treasury or a DST to take up these issues up to 31st of December 2022, where due to these exchange issues, or as you have correctly pointed out, from March 2022, the US dollar was free floated by Central Bank of Sri Lanka, one hand. On the other hand, all the items required to engage in the construction industry and the supply of materials have been restricted by the government. So there are two ways the construction contractors are being put at a very difficult situation. And due to that, some of the performance guarantees were to be forfeited for failure to perform. The cabinet took a decision and gave authority for the procurement entities, subject to the approval of the Secretary to the Treasury or based on the approval of the committee, even not to forfeit bid bonds or performance security and to waive off delay charges on a case-by-case in order to protect domestic companies. So one step they have taken is to invite them, negotiate, and to give some relief, and even in certain instances to consider and terminate the contracts where they cannot perform, but not to forfeit their bid bonds or performance security. And this process is already been approved by the cabinet on 19th of July 2022 up to 31st December 2022, that is in force. Now, if I consider the latter part of your question, especially with regard to the issue when in a such situation can the change in law clause or force majeure clause applies. I am not going to repeat because Justice Masuf enlightened the audience about the Roman Dutch law, how the Roman Dutch law works in Sri Lanka, because in Sri Lanka, as regards contracts, English law principles apply, and where no specific provision is made, the common law, which is the Roman Dutch law, applies. And this was stated in the celebrated case of Da Costa versus Bank of Ceylon, reported in 72 NLR, page 457. I will only quote, it was held where what is important for the present purpose is that the proclamation of 1799 and the ordinance of 1835 did not authorize courts to alter or deviate from the Roman Dutch law or to apply Ceylon principles of English law, which conflict with the Roman Dutch law. From 1835, at least such deviations or alterations could be affected only by the ordinance, unquote. Therefore, these English law principles of frustration are applicable in Sri Lanka, as would be the concept of force majeure, which is a Roman law concept adopted in the Roman Dutch law, which was applicable in Sri Lanka from the 17th century, and based on what type of force majeure or frustration clause is agreed by the parties. Therefore, it's very important to consider what type of a clause is agreed by the parties in the contract. So on an overall, in Sri Lanka, the concept of force majeure, if it's incorporated in the contract, that we will have to give effect, because especially I would like to draw the attention, and I'm sure that Julian will enlighten further, in terms of the FIDIC 1999 clause conditions 8.4, which refers to unforeseeable matters, especially by the government. If I go into the FIDIC conditions on that, it says in the Red Book in 8.4, unforeseeable shortages in the availability of personnel or goods caused by epidemic or government actions. Now, Asanga, you raised the issue. This is due to one thing, it's an unforeseeable issue. Second thing is certain restrictions were imposed by the government. Therefore, it will fall under force majeure. So this is my personal opinion. It does not reflect the opinion of the Honorable Attorney General. We can't hear you, Asanga.
Thank you, Mr. Dharmawathan. I will not hold you to that, if I ever meet you to argue a case, so you don't have to worry about that. That said, can I invite Justice Masu to comment on that?
Yes, thank you again. Let me first say that the De Costa versus Bank of Ceylon, is it? The decision that was referred to by...
Yes, sir.
That decision is... there is a doubt as to whether that particular passage of that judgment coming from Justice Viramantri is good law in Sri Lanka, for the reason that in Kodiswaran versus the Attorney General, which was decided in 1972, I believe, by the Privy Council, Lord Diplock said the common law of Sri Lanka has to develop and it cannot stand still. And there is a recent judgment of the Supreme Court of Sri Lanka by Justice Kodagoda. I cannot recollect the name of that decision, but you can find it. That also follows the same reasoning. And I just cannot understand. In 1972, we had an entrenched autochthonous constitution, which severed all connections with British, the foreign legacy that left to us by the British. And I cannot see any reason why the limitations placed by the proclamation of 1799 should be restrictive in any way. And of course, that's a very gray area which we may have to mitigate by some constitutional provision which gives the freedom to the courts to develop the common law, because the law cannot stand still. Having said that, I must also draw a distinction between two types of situations. That is, on the first change of law, I think if there is a change of law, that will be a frustrating event. And if that makes some performance impossible, then that will be something for which relief can be given. And in fact, that might even make the contract not binding or avoidable. Having said that, I also want to mention in 2017, Act number 22 was enacted by Parliament, which is a new kind of law, import foreign currency related law. And Section 22 of that law, that Foreign Exchange Act, says that the minister, in consultation with the cabinet, can make or give directives which can be published in the Gazette, which will be valid for 12 months, which can in any event make changes in the law and permit certain action to be taken for the retention of foreign currency in Sri Lanka. And under that, if something is done, that will be certainly an action which will be frustrating the contract, and relief can be given on that basis. Having said that, there may be other kinds of things which are not law-based, which are not justified by an act of parliament, but which the government imposes as its policy, which might cause difficulties to contractors as well as those who are served by the contractors. And in those situations, there can be clauses in the construction contract which will have to be carefully read to see whether those kinds of situations can come under it. For instance, the term act of God. Now, there are several United States decisions which have considered whether a pandemic is an act of God or not, and they are inconsistent. They have first held that a pandemic is not an act of God, perhaps act of birds. And another line of decisions which say that it can be regarded as an act of God. So I think more clarity will be necessary in those clauses that have been entered into by the parties for construction purposes. And I think, again, I wish to mention the triggering situations that we have been discussing about. And if there is a triggering situation which causes unforeseeable difficulties to a contract, that will frustrate the contract in any event. Thank you.
Basl. Julian, may I invite you to share your views on this question, and then I will put a couple of questions from the audience.
Thank you very much. And look, it's really interesting for me to listen to those observations about Sri Lankan law, and particularly Roman Dutch law, and the approach to these particular issues. I don't really have that much to say in relation to this question. The one thing that I'm curious about, I suppose, is in relation to the change of law issue concerning the floating of the rupee against the US dollar. Because from what I understand, there is a change of law in order to float the rupee against the US dollar. That's had a negative effect, as I understand it, on contractors, because the rupee has dropped or gone down against the dollar, or the dollar has risen, however you want to look at it. But the question I have, and I don't know the answer to it, is whether the loss, if you like, of the contractor, the increased cost, is a consequence of the change in law, or whether, as a matter of analysis, we say it is a consequence of the market. So that the currency is now freed up and the market has moved. So the government itself did not cause the increase in cost. It was the market forces that did so, and whether that therefore falls outside the scope of a change in law provision. So that's an interesting question. I don't know the answer to it off the top of my head.
Thank you, Julian. I think you just provided a lifeline to Mr. Sumuthi Dharmavardhan. I'm sure he's going to take that line of argument in one of the, probably in one of the battles that he will have to battle for the government in the coming days. Now, that said, let me go to the questions that have been put by the audience. So there's a question for you, Julian. This is coming from Mr. Mukhi Devala. The question is, as a supply chain disruption, if a supply chain disruption is due to COVID, will the contractor be entitled to claim for price escalation?
Well, look, I think the answer to that question is very much dependent, looking at it from an English common law perspective, on the terms of the contract, because I think we've seen from the FIDIC terms that we were looking at before that it's unlikely that COVID causing a supply chain problem would entitle a contractor to payment for increased cost. There might be an entitlement to an extension of time, but not to more money.
May I add that the Suez Canal case, where they closed the Suez Canal, and for navigation purposes, they had to take round the Cape of Good Hope route and increase cost. The courts have held in that case, English courts, I think it was House of Lords, held that that doesn't give rise to any claim, and they have to perform the contract. Because it's only more onerous, but not impossible.
Thank you, sir. There is another question from Romali Tudava. Let me read that out. It says, at the moment, constructors in Sri Lanka are undergoing suspension due to lack of funding for projects where government of Sri Lanka is the employer. If suspension is beyond the contractually stipulated period, how can the contractor navigate liabilities of prolonged suspension, especially in terms of third-party liability at the site, maintenance, rework costs, new rates, etc.? I would invite either one of you to take that question and give a response. Sumuthi, would you like to volunteer?
I'm just running through the question again. If suspension is done. I think now, for example, if the prolonged suspension is due to any other matters falling under the force majeure clause, and especially what has been set out in the FIDIC Red Book, especially under 13.7, due to the certain decisions by the government or due to change of law by the government, then this will fall under force majeure. And therefore, on an issue like that, when the third party liability at the site, the maintenance, rework cost and new rates, etc., all will have to be considered in a claim. But having said that, this is an unprecedented situation, which I encourage and advocate that in a situation like this, both, all three, FIDIC books, the Red Book, the White, provides parties to negotiate. So therefore, it will be very important to start negotiating about this type of issues, but without looking at the particular conditions in the contract, I'm not in a position to give an answer beyond this, but I'm sure Justice Masuf or Julian will be able to help.
Julian is muted.
I don't mind if you want to go first, Justice Masuf. I have a couple of thoughts, but maybe you go first. So
yeah, what I think is that if this is loss or some difficulties caused to third parties due to the action or non-action of the government, in most countries, the government had stepped in to even help contractors, construction industry people, and other industries also. But Sri Lanka, in its present situation, cannot be expected to do so. So as a result, it in fact amounts to a kind of frustrating event which makes things impossible. So my view is that in those situations, the government might become liable because it's in a way, this is again arguable, it's a kind of self-imposed impossibility. Because the government may have been responsible for these situations arising, as some people seem to suggest. I would like to hear Julian on this.
Thank you, Justice Masuf. Okay, reading Rumali's excellent question, one of the things that struck me is it talks about the suspension period going beyond the contractually permitted suspension period. Now that therefore presupposes there is a breach of contract by the government. You can only suspend for a certain amount of time, you can't go beyond that. And looking at it in English law terms, maybe it's similar under Roman Dutch law. That would be seen as a repudiation of the contract by the government. So look, there could be, in a contractual world, a legal world, consequences flowing from that. But I want to come back to what Mr. Samati was talking about before, which is parties trying to work through these problems, because we can look at them from a legal perspective and come up with legal answers, but we're not talking about something which is in the world of the law. This is in the world of the economy, it's in the world of real life. And we need to find solutions to these problems. So maybe in this sort of situation, and I think we all understand the situation, how it's come about, what is best and what is pragmatic, is for people to sit down and say, okay, how do we deal with this? The government hasn't got money at the moment. Suppliers need to be paid. They're not being paid. What can we do?
Thank you, Julian, and thank you to all three panelists. And I will now invite Anuruddha to take over. And it has been a real pleasure moderating this session with the three of you, and thank you for your input. Over to you, Anuruddha.
Thank you, Asanga. Thank you, everyone. I think it's been most enlightening webinar. And now I would like to invite Mr. Manjuka Fernando Pulle, our dynamic convener, who's actually the force behind this webinar. It was his idea. He got Julian involved, and he worked tirelessly through the process so that Dr. Asanga could add on his expertise and contacts, and then get Justice Masud and Sumati, so that we would all have this wonderful panel and the speaker to educate the public in Sri Lanka, the professionals, and also the foreign participants. Before that, I just have just one little comment. I got some messages. A couple of the messages said that we don't want to be named, and said that it is a great explanation on frustration and force majeure. However, could the speakers just take a minute or two and explain the practicality of this? The technical, legal aspects were given. There are non-legal members of the audience. Could the two panelists and the speaker take maybe one short example and give a practical elucidation into the principles of frustration and force majeure? Is that possible? I wonder, because we have non-lawyer members of in the panel, in the audience.
Look, I'm happy to give a common law perspective. I'm conscious this probably won't be of the greatest relevance to people in Sri Lanka, given that Roman Dutch law applies. But frustration of a contract means the contract ends. The contract ends as a matter of law. It doesn't require anyone to do anything. So if a situation is so bad that a contract can't be performed because of some supervening event that neither party could control, and the contractor wants to get out of the contract, or maybe the employer wants to get out of the contract, then the frustration happens automatically. And in order to crystallize it, really, or to confirm it, all that a party needs to do is to say, write a letter saying, because of these events, the contract is frustrated. That's it. So that's my perspective.
I think the question was posted, Julian, more on the lines of what would be the solution, because it says that Mr. Sumati Dharmavardhana mentioned that parties should negotiate. But for example, in a situation like what we have in Sri Lanka, what could you expect from a negotiation? It goes on to say, Sumati, would you care to answer a little bit?
Yeah, certainly, because in a situation what we are facing as of now in Sri Lanka, whether it's arbitration or litigation, it is a protracted process. And if you go for negotiations, I'm sure both parties will be able to come for a win-win situation. As of now, we are dealing with a number of arbitrations due to non-payment, purely due to the economic crisis. And we were able to resolve it very successfully due to the negotiations what we commenced at the pre-arbitration session, and which we continued during the first and the second session of the arbitration. So we have already started with a good faith, and then we have instilled certain confidence that these negotiations are trying to find a genuine solution. So for that, a constructive role has been played by the officers of the Attorney General's Department who hear to the both sides and then try to find a solution. So I think in order to break the ice, we need to start negotiations to understand both sides. And I'm sure Julian will agree with me, because the FIDIC, the latest 2021 FIDIC conditions facilitate and provides, and they want the arbitral tribunal to facilitate negotiations. So in Sri Lanka, we also do that, and then that will, even if you go for arbitration, you have already finished 50% of the battle. I don't want to come out with details, but even few weeks back, we started negotiations, and in the first day of the arbitration, we reached a particular level, and then we had another session within about 7 or 8 days, we entered the settlement. So, but if you go for arbitration or litigation without going into negotiations, it will be a protracted process. And,
Thank you.
people will raise number of legal questions, legal objections. I'm sure Justice Masuf will contribute on that with his experience as a senior judge of Sri Lanka. It will not be an easy task.
May I just say this? Most of the construction contracts have a provision which say that before you go to any kind of settlement measures, you have to first resort to negotiation and discussion for the reason that that will reduce delays, which cost money, as I said earlier also. So those provisions are there already. And very often the cases thereafter go for arbitration. And then, of course, it might be more difficult to negotiate. And I think in the Arbitration Act, there is a provision, the 1995 Act of Sri Lankan Arbitration Act, says that parties can be made to negotiate unless the contract expressly precludes that. So that arbitrator can also set in motion the process of negotiation. But it is difficult to negotiate a situation which is very, very difficult as we face in Sri Lanka. I think that there should be efforts by not only the government of Sri Lanka, but other nations as well, which are facing this kind of crisis. They would understand the situation in Sri Lanka. And I think the government is also having negotiations with other states and the World Bank as well. And there can be some kind of provision for the purpose of assisting the parties to conclude their contracts expeditiously.
Thank you. Thank you, everyone. So now, may I please call upon Mr. Manjuka Fernando-Pulle, our dynamic convener, who put this fantastic webinar together with his team of consisting of Kavita Sivasubramaniam, Neshika De Silva, and Shannon Tissera. So please, Manjuka, take over and deliver the vote of thanks.
Yeah, thank you very much, everybody, particularly Julian. I just took what all this started when I saw Julian's post that immediately after some of Julian's colleagues happened to come over to Sri Lanka and they are involved in the debt restructure process. White and Case is focusing on it. So I thought, and I also saw that Julian's firm is helping train alternative in the Sri Lanka officials with alternative dispute resolution. So I thought it'd be a nice fit to hear Julian, who's one of the world's authority on the matter, and gives his thoughts. I think there was good takeaways from today's webinar, particularly on the statutory adjudication process, and also enlightenment of the FIDIC. I would like to thank thank you, Julian, and hope this is won't be the last time you think about Sri Lanka and give some ideas to solve our problems. I hope you take some time, you get an opportunity to talk about it, and I think there'll be a lot of debt crises happening all the world, and particularly given that your firm is involved in resolving our debt crisis, I think we should hopefully get the opportunity to hear from you and give input into what are resolving our crisis. I would like to thank Justice Masuf for participating and giving a good enlightening on the Human Dutch law. Particularly, I figured there's two different approaches to frustration, or one on Roman Dutch law based on impossibility, while English law looks at unforceability. So there may be a lower threshold in the Roman Dutch law. Thank you, Justice Master, for giving that. And Mr. Sumit Dharmadana, thank you for giving the government perspective and how administrative the government is trying to resolve this. It will be helpful for participants. Thank you very much for that. And not least Dr. Gunawansa for moderating this process. And I think it's good I think it's more fundamentally, it shows to everybody that the Bar Association is constructively engaging and trying to resolve problems and throwing out ideas for the government to take forward. I think thank you, sir, for giving the opportunity, and thank you, Salia, also for giving us the opportunity to host it. And Anuruddha, thank you for moderating it. And the audience, thank you for participating. I think it's good to have a big audience, and it'll be good for us also to take. And my team, Kavita, Neshika, and Shannon for helping me there. And we are going to have another seminar. I'm hoping to have another one on sovereign restructure, which one of Julian's colleagues are helping me to put together. So hopefully we'll see you then on the 26th of January. And thank you very much for everyone participating. Thank you.
Thank you.
Thank you. Thank you. I would also like to thank the
Thank you,
Bar
everyone.
Association staff. Thank you very much. Thank you for supporting us. All the best.
All right.
Thank you, everyone.
Thank you.